Hey, Bob. So thank you for yet again agreeing to sit down and talk to me about what is, for me, a really personal topic, which is CrossFit. So I think we've talked about this before. I've done CrossFit for about 7 years. I'm certainly not a competitive CrossFit athlete by any means. But it is a small but very important part of my life, a part of my family's life. And last week, a very elite CrossFit athlete, um, Lazar Jukic, passed away in competition in the 2024 CrossFit Games. And obviously, this is a huge tragedy, an unprecedented tragedy in the CrossFit Games in CrossFit Games history. Um, it's a deeply emotional time for CrossFit athletes, and a lot of them have expressed a tremendous amount of anger, but also expressed a lack of surprise that such a tragic thing would occur, based on, I think, what they have experienced as a long history of not being treated well as athletes. And so that's really what I want this kind of special episode or episodes to address, which is the legal space that athletes such as, elite CrossFit athletes occupy, which is different than the professional athletic space that we think of when we think about, professional football players or basketball players or baseball players who have contracts, unions, and there's a lot of player protection. So, how do athletes in sports where they are competing as individuals, in a variety of events around the world, around the US, how do they, in other sports, typically advocate for both safe playing conditions, but also their own commercial interests, right? So things like their name, image, and likeness rights, right? Which is something that we've heard a lot about recently.
Sarah, it's a remarkable question, and if we had 2 weeks, we wouldn't scratch the surface of the history of this. But almost every great moment in sports, in terms of its organization, is when a group of players, a group of athletes, have withheld their play because of some issue involving mostly safety or recognition to get a better circumstance. I always think of this story as that the first NBA All Star game to be televised live in 1964. The players from both teams were dressing in the same locker room, about to go out and play together. And Oscar Robertson, the legendary Oscar Robertson, said, "We're not going to go out and play in this game unless the owners recognize us as a union uh, and what we want." And I think, having represented players in a variety of professional sports and being a unionist in the way that I am, having worked in professional sports and labor over the course of my scholarly career and the course of my legal career, I'm always fascinated how this begins and how the dynamic moves forward. Um, if you were a football player, and the demands of the first sets of NFL players back in the 1950s were pretty simple. They wanted a second set of uniforms, 2-a-day practices. They didn't have to put the clammy old uniform back on. And if you've ever done that in your life at any level, you can smell it right now. You can feel it, smell it. It's awful. They wanted not to be cut while injured. They wanted to apportion the risk of injury so that their contracts for a year, if they were injured, would be observed rather than just being fired from the team if they weren't valuable players. And then the last piece, they wanted a per diem that was consistent across all the teams in the league. These are those moments that we've seen, and they're a 50-year period of athletes saying, "Look, we're not going to play unless we get something for this. We know that our play is valuable. We know that the people promoting our sport are generating revenue from this. What do we get from it?" And it takes some time in every sport to do it. And CrossFit's a really good example of where the value has been created in participatory sports over the last decade or so. Uh, Mixed martial arts sort of follow that same formula. Even USTA sort of follows that formula where people play and pay in and own and hold cards, and aren't employees. Mostly aren't compensated, or if they're compensated in the form of some prize money. And they also pay to they pay to participate in the events in a lot of cases. So it's a system that is skewed toward the promoter and away from the athlete. And as athletes and events, obviously, like the tragedy that took place in Texas, uh, as those kind of things happen, it causes athletes to take stock and assess the risk and the reward and the benefits. And we're coming through a huge reckoning of that, obviously, in American college sports, which is an $18 billion business that the athletes have not been able to participate in until about 3 years ago, and still participate at a very modest level. And so, yeah, this is a moment where we live in athletes' ability to have autonomy and control over their labor, over their participation, and over their attributes of that, their name, image, and likeness.
So there are obviously many other sports. Maybe they don't resemble CrossFit in methodology or rules of play, but where athletes are kind of free agents, right? Playing for themselves in order to win prize money, recognition, etc., right? Advancement to the next phase of competition. Some of those, you mentioned mixed martial arts, but there's also tennis, golf, and others, right, where there is prize money.
Which are much more established, right? Yeah.
Yeah, established sports with a lot at stake, right? Um, so, couple questions about that. Are there in these sports, is there a clear dividing line or a clear definitional distinction between those athletes who are considered professionals and those athletes who are considered, amateur or, just.
Sarah, I'd posit that the words professional and amateur probably mean a lot less in 2024 than they meant back in the founding of the modern Olympic movement in 1896. Uh, they were classist statements, essentially. The idea that someone who derives a living or works with their hands is someone you don't want to participate with. And I think the idea that everybody today, in some measure, it has elements of professionalism attached to their athletic participation, whether it's the value of their own name, image, and likeness, whether it's the ability to be free to use their own image and likeness in their participation, free of commercial interest by the promoter, or if they do promote the promoter, they're getting some compensation for it, or at least consideration in that model. So I think the idea that there are going to be athletes of varying degrees of professionalization, but I think every athlete today, in some measure, fits in the more professional model than the not professional model. And in which case, as we kind of begin to think about it from the terms of the tragedy, have certain demands they can make over the people that promote and profit from their sport.
Yeah, so in these instances where you have athletes who are deriving a significant portion of their income, either from winning money within the sport or from activities tied to their identity as athletes in the sport, right? Whether that is brand, relationships, whether that's coaching or marketing themselves or their services in some way.
Absolutely.
How do those athletes typically receive both support and protection from those who commercially benefit from them as athletes?
I think that's the key. From the athlete perspective, you want to identify who's who's providing the benefit and deriving the benefit. So, in the CrossFit scenario, it's CrossFit as an enterprise that has registrants, puts on events, has a format, and then takes entry fees. But they also receive marketing and endorsement dollars in, sponsorship dollars in. And so I think that the group of people that you would want to involve in any kind of campaign to make things better, to make them safer, to provide greater recognition is an accounting of all those sources. So it could come from a stakeholder potentially. It doesn't have to come from CrossFit. It could come from the people that pay into CrossFit to a degree as sponsors. But I think there's a greater aspect now that athletes are demanding these kind of benefits and standards of competition. And here's where I think it really becomes good business. The leading brands in any space, whether it's mixed martial arts or tennis or golf, establish their brand power by offering events with consistent levels of quality and attracting the best participants. So here is where there actually is some alignment. It becomes good business on some ends for an entity like CrossFit to provide the safest, highest standards, highest level of pay for athletes, and ultimately can emerge as the major league in this space. And there are other entities who participate in fitness at a level that are similar to CrossFit. They're not as well known, and in many cases, they may not provide the same standard. But if one did, they might be a very strong competitor immediately.
Mhm. So then, in those more well-established sort of individual sports, like tennis, like golf, how have players so actually, let me before I ask that question, let's just back up for a second and talk about why the traditional type of employee protections that might be available to a professional baseball or basketball player are not available really to athletes in these sports.
Oh yeah, and this is a particularly American problem. It is not quite as bad a problem in some of the nations where your health care or your retirement doesn't necessarily come from your employment. But here in the United States, so many things flow through our relationship as employees: your health insurance, your retirement benefits, your salary, other issues that are related to that. Your insurance in many cases flow through that. Workers comp flows through that relationship, and it kind of comes back to the definition in one of my favorite cases that I cite repeatedly in the unionization non-unionization area, the yeshiva college case where professors were deemed to be were argued to be managerial and not employees, and the subject of the idea they couldn't unionize. So we have a very complex definition under American law of what equals an employee. Some jobs are defined under the wage and hour protections, so secretarial administrative jobs that are done on a paid hourly are sort of defined by government. But things that don't fit that particular framework are easy to argue out. And I think in most of the cases, our participatory sports where prize money and sponsorship are the hallmarks of revenue and income to the athletes, that almost never creates an employment situation. So definitionally, most CrossFitters are not employees of the entity that they're promoting when they're participating in their sport. Now they might be employees of the sponsoring organizations. They might be employees of their boxes. They might be employees of a variety of other entities, but they're not employees in this context. And that's kind of mirrored through the tennis space, the golf space, the Olympic space. There are very few athletes that are actually have employment status in the participation of the sport, which may come back to why I answered the question about are they professionals or not the way that I did. They may make a lot of money through it, but they're usually not doing it through the being direct employees. We're even seeing that take place in college sports, where colleges are now going to be able to pay athletes up to $22 million as a whole at their school. Uh, but they're going to do it through the use of their name, image, and likeness money. So it's going to be a licensing arrangement, not a direct employment relationship. So we're in complex space right now, and it's probably important to know because again, in the United States, we give up so many benefits when we're step outside the employment process. Uh, Charlie Grantham, who teaches over in the Stillman School at Seton Hall, who used to run the NBA Players Association, always has talked about there are hallmarks of being an employee in a unionized setting under both the union rules, under the National Labor Relations Act, and under the labor law. When you're outside that setting, those protections are more shifting and malleable.
Mhm. Yeah, and I think a lot of people don't realize that um, even many employees of businesses, right, are not eligible for union protection. But these types of athletes very explicitly, right, as independent contractors, are not eligible
Yep.
under,
It,
U.S. federal law to form unions.
right.
So, can you talk a little bit about past? First of all, has that been challenged? And do we definitively know, right, that these athletes are not really eligible to unionize or for union protection?
I think, given the state of American law, I think I would say it would be remote to consider them employees unless they were participating at a level and frequency that met that standard. Uh, so they are going to be, for the most part, deemed independent contractors. That's what they're going to also be usually asked to sign by the promoter of an event. And as a consequence, when they're out promoting that event or participating in that event, a lot of the protections that they might have just in tort or in negligence are also signed away as part of a waiver and assumption of the risk. Where we've gotten around that, and where we've seen some traction gained, and obviously there is a professional fitness athletes association out there, um, but it's through professional associations. And again, having the highest quality of athlete, those that are best known in most demand, and have them participate exclusively or in concert with a particular promoter or a particular series of events, again, is a good business and a beneficial cycle, because you're going to see quality play, and you're going to see prize money and standards attached to the event that work really well. I think one of the best examples of this, and it's a little bit humorous that a tobacco company is responsible for this, but the Virginia Slims Tour promoting women's tennis that Billie Jean King helped author was a really powerful statement, because women athletes were not well treated in tennis. They were not as well treated as their male peers. And through that mechanism, the creation of that tour, sponsored by a tobacco company aiming to sell smoking to women, uh, they actually created standards for women's tournaments that ultimately led to equal pay. So there are methods where, if the right athletes are connected and they're able to raise their demands in a way that is positive, there are some benefits that flow from that professional association model. And we see that in golf and tennis, that events that are promoted by the ATP or the PGA have those standards and have a consistency of quality, and also have a consistency of players appearing in them. So I think that's probably the power here, is that the athletes have to both become consistent in their demands for what they're looking for, whether that's safety, whether that's health benefit, whether that's injury protection, whether that's on site injury protection. There are a variety of ways to do this, and to also kind of make sure that some of the waivers that athletes are signing are more limited. That you might be waiving injury risk, but you're not waiving medical care, medical transport. You're not waiving emergency medical transport. So a lot of things to reapportion back to that. And there are a variety of kind of interim bodies. We've talked a little bit together outside of this conversation about the Olympic movement, the 51 sports in the USOPC that are part of the IOC, and they have certain standards, requirements, and coaching. They have also due process standards, and to be sanctioned as an event, you have to meet certain things. I'm on the ethics committee of USA Weightlifting, which is one of my funnier part-time activities. Uh, but and sometimes I'm dealing with weigh-in fights, and sometimes I'm dealing with complaints about social media, people complaining about each other. And I wouldn't say necessarily that it's an optimally functioning business model, but it does provide as a national governing body in the Olympic movement. It provides recourse, it provides due process, it provides standards. It also provides other things in terms of what could a sanctioned meet could be. That it will have certain medical protections, it will have trainers on site, it will have weigh-ins that are neutral. It will have policies about judging, and interesting, one of the ones that we've seen, it will also have policies that prevent discrimination. So it's a
Right.
it's a better model than we're seeing in some of the more purely entrepreneurial sports, and that may be another way, particularly as CrossFit and other entrepreneurial sports begin to seek greater acknowledgement. Maybe they'd want to be part of the Olympic movement and voluntarily do this. But for right now, these are big private businesses, whether we're talking about mixed martial arts, whether we're talking about CrossFit, whether we're talking about other participatory sports. These are big businesses with a variety of standards of care.
But I think what you just said was very important, which is that as a business, they could opt in to cooperative um, arrangements or shared governance with some sort of athlete association who could then establish and negotiate standards, not just for safety, but for other legal protections as well. One of those being waivers, which is something that I want to talk about more.
It makes all the sense in the world to me, but that's why I'm a law professor as opposed to a promoter of these events. In almost every case, I can point to benefits that flow from working together for the to provide a higher level of platform of care, because you'll get the best athletes coming in. The problem in that is that's a long process. The athletes often are negotiating in a very zero sum environment, and probably don't have a hook sometimes to get themselves into the bargaining table, if you will, with the athletes. I always flash back to the demands that the first generation of NFL unionists made, and they were very simple. They were not controversial. They wanted not to be cut while injured. They wanted to have second uniforms, and they wanted to have uniform per diem from every team. The cheap ones would feed them just as well as the kinder owners would. And the owner's response to that was, "You're not our partners. Go away." And it took about 6 or 7 years for them to get there. So these processes can move very, very slowly. It's a tragedy or a reckoning that move them ahead more clearly. One of the challenges, I think, when in coming back to the definition of amateur and professional, is that the body of people who make up the CrossFit community, or any other participatory sport community, don't all have the same things in mind.
Mhm.
An elite athlete who travels might want to have real issues about rest and hotel accommodation and availability and support, where an athlete who's more of a recreational participant would probably not demand those same standards and have different goals. So it's very important for any group in a professional association to take very bite-sized chunks of what they want and reduce it to a single thing or multiple things. Because if you cloud it and you do it across a diverse body of people, it's hard to get any outcome from.
Right, and representation is key, right? Diverse representation. So, speaking of USA weightlifting, which again I know is not a perfect corollary, but I think at least instructive. So, the organizational structure, it's comprised of a board of directors, which I assume is elected.
Yeah, they're elected.
Mhm.
So you, from membership and from the outside world, they usually that board then hires a CEO
Mhm.
who operates it, and then depending on how big the national governing body, and weightlifting is a medium to small one, there are usually a couple full time staffers under that.
Mhm.
Now, the difference between USA Weightlifting is a not for profit and is only in the business of imposing standards and managing the Olympic membership or the international membership in the International Weightlifting Federation. Um, Whereas CrossFit is a for profit entity that promotes its sport. So, but that doesn't mean that they can't coexist. You could have a governing body of professional fitness. That could be the association. That could be a standard agreement through all participants to be a major league, if you will.
Yeah, and I think the PFAA, that already exists, has laid the foundation for that. I think that um, what the athletes who have been involved with PFAA have said is that because CrossFit as an organization, as a corporation, has not always treated them with the level of um, respect or deference or collaborative, spirit that they would like, that it becomes disheartening and it becomes very frustrating and it makes it hard for the association to grow. And so, there would need to be, and I think if I were to say what I would hope to see, there would need to be on the part of CrossFit as a corporation a commitment to partnering with the PFAA, which would enable the PFAA to grow into the type of professional association that can advocate for their athletes in all of these spaces that we've talked about. Um, One thing that I think we as legal professionals should talk about is the inevitable, right, civil negligence claim that will very likely be filed against CrossFit as the organizers of the CrossFit Games on behalf of Lazar's family. So, a couple things. If you read the comments, which is a thing I try not to do, but I have been recently, there are a lot of people, calling for this to happen, saying that it's, an open and shut case, that um, they'll they're going to take CrossFit to the cleaners. And I have some concerns about those expectations, um, given, what I know and what you know about event organizers, also the willingness of corporations to pay out large settlements. I mean, so I think that, if the family, if the athlete's family files a claim, CrossFit may very well settle, right? Because it is not going to look great for them to litigate this.
I
However,
oh,
well,
good.
here is, I think, the one of my concerns, right? In a settlement or even in pursuing litigation, I feel like what is missing in that conversation is that the purpose of civil negligence claims and settlements and payouts, right? It's not just to compensate the family, right? That a human life is priceless and there is no way to truly value it. The higher, like more public policy purpose of these types of civil actions is change, corrective action.
It's to improve the public space, right?
Mhm. So, I don't want to rely too heavily on this notion, right, that like the scales will be balanced through um, some sort of civil claim. Nor do I think there is likely. I was asked by uh, someone at my gym if I thought there was some basis for like criminal charges to be filed, and no, I don't. Um, but I think what I am wondering about is in the sense of how we think about civil negligence and duty of care and the boilerplate waivers that athletes sign where they assume all the risk, they waive all their rights. um, how do we establish or clarify what duty of care is owed to athletes in these types of competitions?
That's a fascinating question, Sarah, and it's one that shifts by state,
Mm.
and it shifts by status. Almost every duty springs out of some relational status under the law, and in this case, I would be concerned at just looking at a case from a long distance, and I'm not a civil litigator in terms of tort and wrongful death, but I'm concerned that Texas will probably be an onerous jurisdiction to bring that case in part because it is favorable to business, and it will anticipate the idea that the athlete's participation involves assumption of the risk, and that the activity involved here is a competitive swimming event in open water, and that was open and obvious to the competitor when he went into the lake. Um, because it wasn't a situation where he was eaten by an alligator or bitten by a snake, but in this case lost his ability to swim and drown. I think that becomes a more difficult proposition with CrossFit maybe asserting, or the promoter of this event, which will be CrossFit, but in many cases will be a subsidiary corporation who puts the event on, because big corporations don't want to have that liability. They'd rather transfer it out to smaller subsidiaries. I think this may not be an easy case to proceed on in terms of a win in tort. I do think it's one that is appropriately settled in the right way, because you don't want to show the community that you are endorsing a risky behavior, or you're endorsing a view that the athletes as individuals and human beings don't matter. So I think it's a case that should settle. Uh, but again, wrongful death suits are seldom as large as we think, and I think we would need to find some level of egregious conduct in it. I haven't looked carefully enough for that. I think the signs are pointing that there weren't enough individuals in life saving roles, either in kayaks, canoes, rafts. There weren't enough people monitoring the open water swim. Um, and that may very possibly have been an issue in negligence. So it's a complex stew here. Um, if the athlete were a student in some cases, or an employee, that might be a higher standard again. And coming back to that, that's a place where we need to. One of the things that you may want to think about most, as a federation, in talking with CrossFit, is maybe there has to be both a standard of care that is consistent across events, and that athletes who are as professional as Jukic were won't participate in events that don't meet that standard.
Yeah, and I did do some looking into the law in Texas, which again, it there may be an action filed in Texas, maybe there won't be. We can only guess, right, conjecture right now, right? But Texas does not generally um, accept an affirmative defense of assumption of risk, except where a participant has expressly in writing or orally agreed to assume the risk,
Okay, got it. Yep.
which I can only assume participants in the games all are required to do.
Yep.
I don't have the agreement that they signed, but I have, a 2016 agreement from the CrossFit Games, and it does include an assumption of risk provision. There are, I think, though, some and even if there is an express assumption of risk, it just mitigates damages. Um, so there is still, right, there may still be a finding that there is a duty of care. However, there is also a waiver of liability in the agreement. So just for those who are, not lawyers or law students, um, that waiver of liability then acts to eliminate, right, any particular duty of care owed to participants.
Yep. And courts, we fight over that as lawyers
Mhm.
in courts to see whether there are facts that make this a case where that waiver should stand, or whether that waiver is overbroad or egregious in this case. So it's not an impossible battle to defeat those. But again, jurisdictionally, there are jurisdictions that read them much more conservatively, and there are ones that read them much more liberally and allow cases to go forward when there is a difference of opinion. And I
Yeah.
can't assess that at this point.
Yeah,
The,
and Texas typically disfavors pre-accident waivers of gross negligence, right?
and that's
So,
you'd have to get to that level of gross negligence, no, and unreasonably dangerous. And then I think the other thing that cuts against that factually is the athlete was very experienced and
mhm,
actually a member of the PAF's European division, so as one of its leaders. So his experience and insight may cut against his ability or his family's ability to claim this. I think it's unique, and maybe there would be medical testimony that would attach to this that I'm not aware of. But open water swims are not an absolutely new, but they're a smaller dimension of what CrossFit entails,
mhm,
and that's a place where if you were looking at it for fodder to argue that standards weren't maintained or that it's a risky thing, that immediately leaving a run to an open water swim may be more inherently risky or inherently dangerous from a medical perspective. Um, Again, triathlons have gone on, and there have been deaths in triathlons, and USA Triathlon it sort of is another good example, because triathlon's an Olympic sport. There is a national governing body. There are insurance requirements that are attached to U.S. Triathlon Association sanctioned events, and there are events in triathlon that are more tour oriented or more entrepreneurial. So they exist or coexist in that space, that hybrid space, and that may be where we see the ultimate CrossFit world moving toward a place where it exists both in a more controlled governmental and nodding environment, because it's not government run, but the government gives sanction to it, and in turn, it may have higher standards as a result.
yeah, I mean, I think one of the things that complicates that analysis is that CrossFit, by definition, um, is is about physical tasks that are unknown and unknowable, right?
Yep.
So there, I think, unfortunately, is an argument to be made, right, that you know when you assume the risk in CrossFit, you assume the risk of things that even you may not be able to predict, right?
You're pressing the limits of human performance, and that becomes a
Right.
risky proposition right there, and that it's unpredictable. And I think that would be where, if I were putting a case together in this case, I'd want to get some sense of what is the risk of any athlete in this environment moving from one event to the other.
Right. Well, and I really don't necessarily want to, lawyer from the back seat, what Lazar's family, may do from a legal standpoint. That is, they should
Yep.
explore all their options and hopefully, achieve some sense of satisfaction and justice through the court system. But I think what I would like other athletes to take away from it is that they give up a lot of their rights when they enter into these types of competitions, and that they may not be taken care of by our justice system in quite the way that they would hope or believe,
Yep.
um, because of that relinquishment of those rights. And that is something that I think, as you said, a strong athletes association could hopefully address and negotiate for more explicitly on athletes' behalf, so that it doesn't take an act of gross negligence for an athlete who loses their life or is seriously harmed through an act of ordinary negligence that they can't recover.
No, and I think you're exactly right that this tragedy hopefully will serve as a springboard for more serious consideration of what the relationship of the athlete to the entity of CrossFit is. That they are valuable, that they need certain protections because those protections don't exist in law, that they need them from the contract, from their participation. And those things need to be negotiated as part of private agreements as opposed to being imposed by law. The
Right.
only thing you kind of look at, I've talked about this obviously in the context of name, image, and likeness in the college space, is that the courts in the United States have ruled that all of us have a right to our name, image, and likeness. And I then kind of move into to a Wilson Pickett song off that, "You, Me, Everybody has the rights to their NIL." So the idea that they could be appropriated or used or suppressed without justifiable compensation as part of a waiver is another reason to reconsider those waivers in a way. So it's
Yeah.
not an unimportant prospect, and it is, I think, a part of the growing pains that all sports need to go through, and we're seeing it in unique ways in other sports. My mind is popping right now to the National Women's Soccer League, where abusive coaching was something that the players have now tried to root out of the sport, or gender based discrimination from coaches, is something they've tried to root out of the sport. Every sport comes with its conflicts and growing pains. Uh, Tragedies like this, we focus on ways to make them better.
Yeah, so I think that's a great place to consider, um, as an attorney, as a sports law attorney specifically, and as someone who worked within an institution to address issues of compliance, and improve culture uh, in a place where trust had been deeply, deeply eroded. If you had to say, what is the one thing that CrossFit as an organization needs to do to rebuild trust and confidence and um, the faith of their athletes and of their community, what would you say that is?
They're taking a step to have a neutral investigation. I think a neutral dialogue with their athletes is maybe the most important part, whether that's a study, uh, involving a law firm or a consulting firm to survey the athletes, whether that is a series of dialogues with the athletes. But you're right. This event, this tragedy, comes also at a time, or magnifies a lack of trust. And I think that the way to rebuild that is to show that you care about the athletes with reason and purpose, because again, you can't show more profit, better competition without showing that care.
Right. So some sort of, again, in addition to an investigation, a third party consultancy to assess and address that dynamic between the organization and the athletes.
in a way that's more meaningful than just
Yep.
papering the file.
Yep.
Yeah.
Yeah. All right. Well, I really appreciate you agreeing to do this on such short notice. Again, this is, more so than, season one or season two topics, something that I am deeply connected to on a personal level. And I'm really um, grateful to you as my colleague for helping me to put this together.
Well, I'm thrilled, and I know how important CrossFit is in your life, and then the relationships that you derive from it. It is one of the things that makes the sport great, and you want to make sure that any sport you care about is sustainable.
Absolutely. And that's, I think, at the heart of why, I wanted to add my voice to this conversation. So thank you very much.
It's very eloquent. Thank you.